how cool is this?
The Supreme Court today handed down a major victory for gun control advocates.
Major decision from the Supreme Court that could have larger implications on gun laws nationwide.
As the nation deals with a recent wave of mass shootings, the Supreme Court expanded gun rights.
The majority of the court ruling the Constitution protects a person's right to carry a gun outside the home.
Government may not regulate individuals' possessions of weapons for self-defense.
A federal appeals court just dropped a bombshell on California, and the shockwaves are rippling through every gun control advocate's carefully constructed worldview. What happened in that courtroom fundamentally challenges everything California has been doing with gun rights for decades, and the implications go way deeper than you might think. Here's what went down. California's ban on open carry just got struck down as unconstitutional. Now, if you're sitting there thinking this sounds like some alternate reality news story, you're not alone. California treating the Second Amendment like it actually exists? That's about as rare as finding a parking spot in downtown Los Angeles that doesn't cost your firstborn child. But this ruling isn't just about guns. It's about something much bigger. The fundamental question of who gets to decide what rights mean and whether states can simply legislate away constitutional protections because they make people uncomfortable. The law that just got struck down would have banned open carry in counties with more than 200,000 people. That's basically every major population center in California. The judge who made this ruling, appointed during the Trump administration, based the decision on recent Supreme Court precedent that requires firearm restrictions to be consistent with the nation's historical tradition of firearm regulations.
This is big.
This is an issue that every gun owner should be concerned about, and we in Congress should be concerned about it too.
We want to see Congress pass laws that will help reduce crime without infringing on the rights of law-abiding citizens.
There is a difference between states deciding how they want to regulate any number of things versus stripping people of their rights to self-defense.
Public safety concerns must be addressed in ways that are lawful. This rule is not.
Let me break down why those words matter so much. What the court is essentially saying is revolutionary for California. You don't get to create gun laws based on modern anxieties. You don't get to restrict constitutional rights because seeing a holster at your local coffee shop makes you nervous. If you want to limit a fundamental right, you need historical precedent, not contemporary discomfort. This creates a massive problem for California's entire approach to gun legislation. For years, the state has operated on the principle that if something feels scary or looks intimidating, they can ban it. This ruling says no, feelings aren't facts, and discomfort isn't constitutional grounds for prohibition. Now, before we go further, let me clarify something important. This isn't about whether everyone should strap on a holster tomorrow morning. Many gun owners, myself included, prefer concealed carry for tactical reasons. If you're openly displaying a firearm, everyone knows you're armed, including anyone with bad intentions. That makes you target number one in any dangerous situation. But here's where the logic of gun control advocates completely falls apart. If you're genuinely concerned about public safety and the presence of firearms, open carry should theoretically be less frightening than concealed carry. With open carry, you can see exactly who's armed. You can choose to leave, avoid that person, or simply go about your day with full awareness. With concealed carry, you have no idea who's armed around you. The truth is, in any moderately populated area, you're probably surrounded by concealed carriers every single day.
It's a case that legal experts will be watching closely.
We won't see changes overnight, but it's going to be quick.
House would keep gun owners' information private.
Justice's ruling this morning, it conflicts with the Second Amendment's right to bear arms.
In a 6-3 decision, the court struck down New York's law, which places restrictions on concealed handguns.
That person next to you at the grocery store could be carrying. Your Uber driver, possibly armed. The mom at the playground, she might have more than juice boxes in her bag, but because you can't see it, you don't panic. This reveals what's really going on here. Opposition to open carry isn't about safety, it's about comfort. It's about not wanting to be reminded that we live in a world where people exercise their constitutional rights in ways that make some folks uncomfortable. It's about maintaining the illusion of a gun-free environment while being surrounded by concealed firearms. California's Attorney General Rob Bonta responded predictably, saying his office is considering options and remains committed to defending California's common-sense gun laws. But here's the problem with that phrase, common sense. Whose common sense? The common sense of California politicians? The common sense of people who've never held a firearm? Or the common sense of the Constitution and centuries of American tradition? What makes this ruling particularly significant is the historical context of California's gun laws. Many people don't realize that California's strict gun control has some deeply problematic roots. Back in the 1960s, when the Black Panthers began exercising their Second Amendment rights to patrol their neighborhoods and monitor police activity, California Republicans, led by legislator Don Mulford, suddenly discovered their passion for gun control. The Mulford Act, signed by then-Governor Ronald Reagan, banned the open carry of loaded firearms in public places.
Will allow scrutiny for all gun laws pertaining to everything: assault weapons, age restrictions, restrictions on magazines.
Court will consider whether people who use marijuana can legally own guns.
Saying setting a higher threshold in an emergency could mean life or death.
State can't make everywhere a sensitive place. You can't go hiking in some places and not be able to defend yourself against somebody that you run into.
The timing wasn't coincidental. It was a direct response to Black Americans exercising the same rights that had been taken for granted when only certain demographics were doing it. This historical context matters because it exposes an uncomfortable truth. Gun control in America has often been less about public safety and more about controlling who gets to exercise constitutional rights. When the wrong people start carrying guns, suddenly politicians discover urgent public safety concerns that didn't seem to exist before. This federal court ruling forces us to confront these historical realities and ask hard questions about the true motivations behind gun control legislation. Are these laws really about safety, or are they about comfort? Are they about preventing violence, or preventing certain people from exercising their rights? There's another aspect to this that rarely gets discussed: the practical impact on women. Many women's clothing isn't designed for concealed carry. Tight-fitting clothes, dresses, outfits without sturdy belt lines, these make concealed carry difficult or impossible. So what happens? Women are often forced into less secure carry methods like purse carry, which presents its own risks and challenges. By banning open carry, you're essentially telling women they need to completely change their wardrobe or compromise their self-defense options. How exactly is that empowering? How is that supporting women's rights? The same people who claim to champion women's autonomy are perfectly happy limiting their practical self-defense options.
That major decision from the Supreme Court that could shape how federal judges exercise their power moving forward.
This case could reshape how far states can restrict your right to carry and where.
This is something that actually comes from common law England. The king is sovereign, and the government has to waive that sovereign immunity.
The right to keep and bear arms shall not be infringed.
The ruling also highlights a fundamental disconnect in how we approach rights in America. We don't get to pick and choose which constitutional rights we like based on our personal preferences or political leanings. You don't get to support free speech only when you agree with what's being said. You don't get to support due process only for people you like. And you don't get to support the Second Amendment only in ways that make you comfortable. Rights are messy. Rights are sometimes uncomfortable. Rights mean that people will do things you don't personally approve of. That's not a bug in the system. That's the entire point. A right that only exists when it's popular or comfortable isn't a right at all. It's a privilege granted by the majority, and that's exactly what the Constitution was designed to prevent. This ruling represents a significant shift in how federal courts are approaching Second Amendment cases. For decades, courts often deferred to state and local governments on gun regulations, essentially allowing them to chip away at constitutional rights through thousands of small restrictions. But recent Supreme Court precedents have changed the game, requiring historical justification for modern restrictions. This doesn't mean every gun law is unconstitutional. It doesn't mean we're heading for some Wild West scenario where everyone's walking around with six-shooters on their hips. What it means is that governments need actual constitutional justification for restricting rights, not just fear, not just discomfort, not just, we've always done it this way in California. The people panicking about this ruling seem to envision a world where everyone's suddenly going to strap on a gun and head to Whole Foods looking like they're auditioning for a Western. That's not what happens in states with open carry. Most people who carry still choose concealed carry. Open carry remains relatively rare even where it's legal, but having the option matters, having the right matters, having the government acknowledge that it can't simply ban whatever makes politicians uncomfortable, that matters.
For the Supreme Court, it's all about language, reasonable suspicion, objective reasonable belief, or probable cause.
This will get appealed, and this might go back and forth a little bit, but for right now, this is where we're at.
When things sound really good for gun owners in court, that doesn't mean it's over.
The Second Amendment protects the right to carry a gun in public for self-defense.
What's particularly telling is how this ruling exposes the arbitrary nature of many gun restrictions. If open carry is so dangerous, why is concealed carry allowed? If seeing a gun creates panic, why are armed security guards acceptable? If the mere presence of a firearm is threatening, why do we allow off-duty police officers to carry? The inconsistencies reveal that these laws are more about social engineering than public safety. This ruling should serve as a wake-up call to states that have been treating constitutional rights like suggestions. You don't get to regulate rights out of existence through clever wordplay and incremental restrictions. You don't get to create a de facto ban by making the legal requirements so onerous that nobody can comply. And you definitely don't get to ignore Supreme Court precedent because you disagree with it. For gun rights advocates, this ruling represents hope that the judicial system might actually start taking the Second Amendment seriously. For gun control advocates, it's a reminder that their preferred policies need constitutional grounding, not just good intentions. And for everyone else, it's a lesson in how rights work in America. They're not subject to popular vote or political wins. The battle over this ruling is far from over. California will almost certainly appeal, and other states with similar restrictions are watching closely. But for now, a federal court has said what many thought they'd never hear. California can't simply ban constitutional rights because they make people uncomfortable. Whether you own guns or not, whether you support open carry or not, whether you live in California or not, this ruling affects you because it's about more than guns. It's about whether states can legislate away rights they don't like. It's about whether constitutional protections mean anything in practice. It's about whether we're going to be a nation of laws or a nation of feelings. That's it for today, folks. See you in the next video.